Hi, everyone, and thanks for joining us again today. We're happy to bring back Tatiana Melnick, who is an attorney at Dickinson Wright. And Tatiana has extensive experience in the area of healthcare and technology law. She's here with us today to answer questions specific to sharing PHI data and how to avoid pitfalls in meeting HIPAA compliance when you're working with partners and other legal implications of business associate agreements. Thanks for joining us today, Tatiana.
Thank you so much for having me.
So we know that a lot of people are sharing concerns, especially after recent media, seeing that Stanford Hospitals had a breach and TRICARE has had a breach, and the data is bearing out that when a business associate is involved, that sometimes the breaches can be more severe. So I think there's an awareness perhaps that people need to be protected, but maybe there's still some uncertainty as far as when you need to have a business associate agreement in place. So are there any examples of companies that are sharing PHI data, but it might not be readily obvious, or applications where people might not realize they should be protected?
That's a really good question. Before we go into that, I'd like to just go ahead and get a few definitions out of the way, which I think will help answer this question. In general, people usually know when they have PHI. It's one of those things that if you are in healthcare and you have people's personal information, you know it. It's not an accident. But there have been, and there are instances where people don't really know it's PHI or that it's legitimate, active medical data. And I'll give some examples of that a little bit later on. But before we get into that, I want to go ahead and just talk a little bit about some definitions. And the following definitions come directly from HIPAA Administrative Simplification. And I'm also going to reference some of the materials from the the interim final rule that was proposed last year. And because it's an interim final rule, it actually is in effect, even though it was a proposal. That's just the way the administrative structure works, which is why you see a lot of people sending out the high-tech modifications to business associate agreements and putting all those processes in place already, because that's what makes clear to us as attorneys and as people, as practitioners in the area, that is where HHS and OCR and the whole healthcare government space is moving to additional protections for everybody who has contacts with PHI. So what is PHI? It's basically data that's transmitted or maintained in any format, right? It's either electronic or paper records or anything. It incorporates anything that has to do with people's individually identifiable health information. This is how you know an attorney drafted it, because there's a definition within a definition.
So even if it's on the back of a napkin.
Right.
Okay.
That's right. There are some things that are excluded specifically from the definitions, like employment records, education-related stuff. So, but for the most part, the stuff that we're dealing with here is not going to be things that are excluded. So what is individually identifiable health information? And that's definitely a tongue twister, right? It's basically people's medical information. It has to do with the past, present, or future physical or mental condition of a person, or the provision of healthcare services to them. Clearly, that's really, really broad, right? That encompasses billing, that encompasses any kind of processing. Under high-tech, EHR vendors are specifically covered explicitly under the actual statute. So again, it's very, very broad. And that matters because, as you said, are there surprises where people wouldn't really know that they have PHI? And in some cases, yes, because you don't know that what you have is live data. You don't know that what you have is medical data. And I'll give a little bit of an example of that later. But I know that people are wondering, am I a business associate? Under what circumstances am I covered, and do I have some responsibility, even though I may have PHI, but I may not actually be using the PHI in some way. I am just making some ancillary processes, like I'm just sending out billing statements, or I'm doing something minor to the data. Does that still count? And the answer to that is yes, it does. It's because it relates to the provision of healthcare services. It's people's past, present, or future physical or mental conditions. And so, yes, it's incorporated into that.
So even if there's not a lab result or a specific diagnosis involved, anytime you're dealing with records that involve patients, it's still,
it is.
You need to be aware.
Absolutely. Absolutely, you need to be aware. And that Stanford example that you mentioned, which I use later on, is one of those circumstances where, in fact, there was only one diagnosis in the data. It was somebody's psychiatric diagnosis. Everything else was the person's name, their admission date, which doesn't necessarily seem like it would be PHI because it's not really their mental condition, right? But because it talks about them being admitted to a hospital, something happening there, then it is PHI. It is protected.
Okay. So is there any situation that involves the exchange of PHI data that does not need to meet HIPAA compliance, or should everyone assume that anything that involves patients should always be protected?
There is one major exception. And before I get into that, let me just talk briefly about when you fall into the business associate category, and then I'll work my way into that exception, because you sort of have to understand the framework of when you are a business associate to know when you're not.
Okay.
A business associate is a person who performs or assists in the performance of a whole bunch of functions for a covered entity, right? It's the person who actually is the originating entity that has the PHI, like a hospital. And it involves the use or disclosure of individually identifiable health information. Here we go again with that big definition that encompasses everything. Basically, it means that if you do services for a covered entity and you handle in any way protected health information, you're going to be covered, right? So that is a big deal. And you can see in the statute, in the administrative simplification, the regulations actually, there's a list of entities that are covered. And that includes legal, attorneys are covered, actuarial, accounting, consulting, data aggregation services. There's a whole bunch. And again, these are services that would typically have access to that kind of information, right? So for example, our clients don't generally have us sign business associate agreements, because when they come to us, they're in litigation, right? And there are certain exceptions for litigation, that if you choose to sue a doctor or you choose to sue a hospital, you are automatically giving permission for someone to display your information, because going to court is a public process, right? Your records are only sealed and hidden under certain circumstances. And there are exceptions for HIPAA, so you do, when you request medical records, there are certain things you have to block out from a medical record. Your accounting, right? If someone, again, is providing you with accounting services and they see people's PHI, the treatment how long they stay at the hospital, because they need to know that to charge them, right? That's PHI. That's included.
Okay.
One of the bigger changes to this space has been the inclusion of subcontractors. So you have your covered entity, you have your business associate, and then you have a subcontractor, which is some other service provider that provides services to the business associate. They are also covered, right? And that's one of the things that the interim final rule makes very clear, is that they are covered. And why are they covered? And I included this language from the interim final rule, and it says, the proposed provisions avoid having privacy and security protections for protected health information lapse merely because a function is performed by an entity that is a subcontractor rather than an entity with direct relationship with a covered entity. Basically, what they're making clear is everyone is covered. If you touch PHI, you're responsible. So to go to your question, who's responsible for complying? Everyone who touches PHI is responsible, period. There are no exceptions to that except for the exception.
Okay, which is, and we're ready for it.
Let me get to it. Okay, so who is not covered? It's someone who acts as a conduit for PHI. What does that mean? Well, that means that if you're the Postal Service, if you're online tech in certain circumstances, you are Google, you're whoever else, right? You act as a conduit to transfer the data. And you're not someone who on a regular basis or maybe not regular, but normal basis would have access to PHI.
So someone who's passing PHI from place to place may not be liable or required to meet HIPAA compliance.
Right.
How does that work in the technology world when it's really tough to tell, you know, what a vendor can see and what they can't see?
Well, this is why you're never going to have a covered entity. It's very, very rare that you will have a covered entity that will agree with a service provider like Online Tax or like Rackspace or whoever to say, hey, listen, you're providing these services, but you don't have to sign a business associate agreement because you don't actually technically have access to it. In fact, you do, right, because you house the servers. Your people once in a while go and make modifications, right? And so because of the damages and because of the huge liability, they will require that they sign a business associate agreement, even if it is possible that they may not have access to the data. So you'll see this, for example, with Microsoft Pitfalls service. They will argue till they're blue in the face that they are not a business associate. And yet, they have put forth a business associate agreement that they're willing to sign. Granted, it's a modified version of a business associate agreement. There's very limited provisions, but it's still there because they recognize that no one will use their service without some degree of protection.
So even if you might be lucky enough to fall in that category,
right,
where you're excluded,
right,
it's if you want to do business in the healthcare IT space,
right,
you can expect that covered entities are going to require you to sign that business associate agreement.
If you are storing their data, if you're housing their data, if you're doing anything like that, they're going to require that you sign that business associate agreement.
So who or what does the business associate agreement protect?
The business associate agreement protects everybody. From my perspective, it is in your best interest to sign an agreement. If you do not have an agreement, I'd like to make clear that even if you don't have one, you are still responsible. So having an agreement in place or not having an agreement in place does not mean that somehow now you get out of being responsible for complying with HIPAA. It's just not the case. And let me get to a slide because I have, and it's not me saying this. It comes directly from the Department of Health and Human Services. So this is, again, in that interim final rule, where this comes from a section where they've made a few changes to the current HIPAA administrative simplification where they set forth all these requirements. And they say, the movement of these exceptions and refinement of the definition of business associate also would help clarify that a person is a business associate if it meets the definition of business associate, even if a covered entity or business associate with respect to a subcontractor fails to enter into the required contract with the business associate.
So the short version is whether you're willing to sign it or not,
right,
you are
if you fall in that definition, you're responsible, period. So the reason that you would want to have an agreement in place is because, one, you're meeting your statutory obligation, right? You are obligated by statute to enter into a BAA. So again, you're showing you're compliant, step one,
okay,
right? Step two, you have taken the time to evaluate your compliance requirements. There are certain things that you as a business associate will not do. For example, if you are creating internal software for a hospital, right, where you are not making any kind of disclosures outside, right? So for example, you don't need to have an accounting of disclosures because you're not disclosing the data, right? So there are certain things that you will not have to do, and so your agreement with the provider clarifies everyone's responsibilities, which is what you really need to do, because if you're not providing services, specific services, then you should not take on the responsibility for complying with those provisions, because that's extra work for you, right? So it protects everybody. It protects both parties, and it's important that you read your business associate agreement. They are not the same. Okay? There are differences between. They are generally very similar because of what's supposed to be in them is defined by statute or by regulation. So they will be very similar, but they're not the same. People can add things to them. They can make modifications, as I've noted. And so you should be careful that you review what you're signing, because you want to know what you're obligating yourself to do.
So it sounds like the opportunity to draft and review and agree to a business associate agreement with your partners is a good opportunity to know exactly where you stand, to draw your lines and establish where the sandboxes are so everyone is on the same wavelength from the beginning.
Absolutely.
Before something happens.
Absolutely, and that's exactly what you want to do. And I want to, on that note, I want to go ahead and briefly mention the Stanford case, which is just amazing. It's just a really great example of the kind of problems that arise. And frankly, this is something that arises in all kinds of contexts, right? This isn't just specific to HIPAA. You always have people that you contract with. You have entities that provide services to you, and someone just makes a mistake, right? Unfortunately, in these cases, it's a very expensive mistake. I would like to know, under this case, there has been a lawsuit filed, the class action in California, but it has not been filed under HIPAA. It's been filed under one of the California statutes, that's Confidentiality of Medical Information Act. And I bring that up because HIPAA is not people's only remedy, right? Almost every state, I think every state has confidentiality laws related to PHI. And so it's important that you understand that you don't just have to comply with HIPAA. You have to comply with your state requirements as well, because those can get you too, right? So you have to be careful that you know the area you're operating in. In the Stanford case, you had data released on 20 emergency room patients. And in that case, a person applying for a job received an Excel spreadsheet from one of the people looking to hire her, and they said, hey, would you go ahead and do this for us? And she didn't know how to do it, so she posted it on a tutoring website and said, hey, can you help me, please? Right?
No.
Exactly. So clearly she probably wasn't qualified for the job because she didn't know how to do it, right? Number one, let's just put that out there.
Maybe safe to assume she didn't get the position.
No, she didn't, but in the interim, she compromised people's data. So if you think about it, whose fault is it, right? Stanford has this business associate that provides services to them. The business associate hires a marketing company to hire someone for them to do this job, right? And I will say it's not clear whether they hired this business associate hired some third party or if it was their own, internal marketing person.
Okay.
But so they put this out looking for someone, and lo and behold, they use live patient data. So this is what I mean, that sometimes you just don't know that's what you have, right? You think you have test data. This is what you can use to test people's skills. Well, no, it's not test data. It's live data. And of course, who's in trouble? Who is getting sued in the class action? It's Stanford.
Yep.
Right? So that's why covered entities will never let you hold their data without you signing an agreement because of stuff like that. Because now they're going to look to their agreement. They're going to say, hey, business associate, look at this. We have this giant indemnification clause. Pay up, right? Because that's part of entering into this agreement. And so your standard business associate agreement, if you just follow the rules, is not going to have an indemnification clause, right? So if you're just signing BAs left and right, you're not looking at those things. You have to make sure that unless you have some other agreement that covers that relationship, if you're just signing the business associate agreement, you need to make sure that it is a full agreement. It has a governing law section. It has an indemnification section, talks about data destruction, all the things that an agreement would have when it comes to protected data.
Well, at the level of these penalties, this is pretty serious business for a lot of vendors. I mean, probably the difference between being in business and not in some cases.
Exactly. And so I know a lot of vendors are looking for insurance options. I would like to note there are insurance options available. I know the insurance industry is actually trying very hard to price point these because this is a relatively new area. Cyber law insurance has been around for a long time, but specific to this is a relatively new area because now penalties are mandatory. But there are options available. If anybody out there is interested in learning more about that, just send me an email, and I have a list compiled
Super. And we'll post Tatiana's contact info on the website and share that link for anyone who wants to ask questions about those resources. So it sounds like healthcare vendors are much more at risk if they don't sign a BAA. There is no avoidance of risk or penalty if they don't sign a business associate agreement.
That's
really
exactly right. So you have, under the statute, you have a clear requirement that BAA should be signed. If you don't, as OCR and HHS have made clear, you're still responsible. But now what you're missing is an indemnification section, right? You're missing warranties, you're missing indemnification, you're missing all these other things that you should have. And if you didn't sign that agreement, you don't have those protections.
And you haven't done your due diligence. So
right.
a whole
you're
new
definitely
level.
Getting investigated. And I think Joe talked about this in his first session, where he gave a list of the things that what happens when a breach happens, right? You get that letter from OCR saying, please give us this, and you have 10 days. And that includes your policies and procedures, that includes all of these things that you cannot possibly prepare in that little amount of time.
So if you don't have that ready to go before an incident happens,
now you're willfully
just
negligent.
compounding the situation.
Yeah, well, because now you're willfully negligent, which means your penalties just basically doubled, and they're mandatory. So it's a problem.
BAAs are the way to go. That's what I'm hearing. So is there a change in attitude of the large healthcare organizations related to their willingness to do business with companies? It sounds like you've already answered this, that really it's to the point where you're just not going to do business with a covered entity unless you're entering into an agreement.
Absolutely. It's one of those things that really is standard in the industry. It's a standard requirement, and if you want to enter the healthcare market, you need to be prepared to sign them. And so you really should have your attorney review the documents and make sure that they conform to what it is you do. They're limited to only your specific services so that you're not taking on unnecessary liability. And that's really important, because what you don't want to see happen is your BAA says you're required to do steps 1 through 3, but you only do step 3. And so you should never take on liability for steps 1 and 2. But if you don't exclude that from your agreement when a breach like this happens, I don't think that's going to matter, right? Because they're going to say, well, you agreed to take those things on. You don't do them, well, too bad.
So you need to make sure they're specific to your actual business and your processes.
Right.
What about someone who signed a business associate agreement 2 or 3 years ago? Are they still valid, or have things changed enough that maybe those all need to be revisited at this point?
No, they're still valid. Generally what will happen is if you signed one a couple years ago, you should have gotten an update saying, here's the new provision for HITech. Because HITech put in place breach notification requirements, and those have to be appended to existing business associate agreements. A lot of providers and vendors have taken the opportunity to actually review their agreements at this time and make sure that they're still consistent with what they're doing, and they're still consistent with the requirements and consistent with how BAAs have been determined and interpreted by judges when they have been litigated. But for the most part, they're still very, very valid. The only thing that you really need to do is go ahead and update to include the breach notification requirements.
Okay, good to know. So we had some of our webinar registrants submit questions upon registration, and we noticed a theme that there were a lot of people asking about what happens when PHI is involved in clinical research. And just wanted to invite everyone, if you have any additional questions that you've come up with during the webinar, go ahead and send them to us in the questions or the chat dialog box, and we'll try to fit those in before we wrap up here. But getting back to PHI in the clinical research arena, what are the liabilities there?
So first you have to evaluate what it is you're doing, right? If you have PHI, and there was also a question from the telecommunications perspective on what people who are providing telecommunications services, what they have to do to comply. First, you have to determine whether or not, for the telecommunications space, whether or not you're a mere conduit, right? Because if you're AT&T and you're providing the backbone of the internet, you're definitely a mere conduit and you're not entering into those agreements.
Okay.
Okay. If you're AT&T and you're providing your EHR system, then that's a little different. So
Okay.
you have to figure out what you're doing. And in that vein, these questions are very, very fact-specific, right? So it really depends on what it is you're doing. If you're processing PHI, you are acting on PHI in some way, your requirements are no different than anyone else. You need to do your risk assessment, right? You need to have your policies and procedures in place. You need to train your staff, because all of that, it's the same. It's the same process for anybody who has access to PHI. It's more of, you just want to make sure you determine whether or not you're actually subject to it.
Okay, great. Good to know. And we've got some more questions submitted here. One is, as is a data center a business associate?
A data center, so you would have the situation like you have with online tax, right, where they provide data center services. Some will argue that a data center is a mere conduit, and so they're not subject to it. Okay, I would, from my take, okay, having evaluated some of these issues in the technology space, depending on what this data center is doing for you. Okay, if they are managing your servers, if they're going in and making updates and making changes and doing all kinds of stuff, they're a business associate. On the other hand, if it's just co-location where you go in and you plot down your own equipment, you lock it in a cage, no one has access to it except for your personnel, then they're not a business associate. So it's a very fact-specific, very, very fact-specific. But again, I'm a hospital. I'm Stanford, right? I just got a class action suit against me from a business because of a screw-up by a business associate. Am I going to trust what happens if you do not sign that agreement? First, I'm going to start wondering, wait a second, why aren't you willing to sign an agreement that basically says you have to follow all of these security requirements?
Right.
Right? Are you not following the security requirements? What's going on? And of course, your answer is, well, I don't want to take on additional liability that I don't have to take on. Right? I don't have to do all of these things because I don't provide these services to you. Yes, I may do a risk assessment. I may do all this other stuff, but you're obligating me to take on additional stuff under statute and federal law that I shouldn't have to take on. And you as the covered entity are going to say, I'm pretty sure I'm going to find someone else who will be happy to take that on.
Right.
And you're going to walk away.
Right.
Right.
I've noticed even in our experience here that when clients come specifically looking for PHI data storage, doesn't matter if it's co-location or managed servers, first question out of their mouth is, are you going to sign a BAA? And, yes or no, and then they're out the door. So
that's exactly right.
Okay, great. Thanks for that question. Here's another one. Is the bank where we store our backup tapes of PHI a business associate of a covered entity?
It depends on how you're storing it. I'm assuming you have some tapes or some disk drives and you put it maybe in some sort of vault. First, that stuff should be encrypted, right?
Data at rest should be encrypted.
Data at rest should be encrypted.
Okay.
And if it's encrypted, then probably not. I mean, I think that banks probably under those circumstances will not sign business associate agreements.
Okay.
Because it's locked away. Who has the key? Probably just you and some third party or whoever, however you have it stored. So I'd say, depending on how it's stored and what's going on, probably not.
Okay. But the story might be a little different if you are taking your digital PHI data and you're trying to back that up remotely. Using someone else's storage service.
Absolutely.
Then they're going to be
Yeah.
on the hook. Okay.
Yeah.
Okay. That's a good clarification. Is it typical for the BAA to have a cap on the liabilities that a subcontractor has for a breach of the agreement?
That's actually a typical provision in many types of agreements. BAAs are usually ancillary documents. So you'll have your main services agreement, and then you'll have Exhibit A, the BAA. So you may not have it in the business associate agreement, but you may have it in your main agreement. If you do not, you can absolutely add that into your business associate agreement.
Okay, good to know. The next question is, many business associates have not completed a risk assessment and analysis, which is now required by the HITECH Act. Paradoxically, many covered entities are also in the same boat. Do you have any suggestions on where business associates can go to get guidance or templates on how to complete such an assessment?
The Department of Health and Human Services has some really, really great materials. There's also a site called the HIPAA Cow.
The HIPAA Cow?
HIPAA Cow.
Okay. Memorable.
It's a great name. It's the HIPAA Collaborative Organization of Wisconsin. And so their acronym is HIPAA Cow, and it's HIPAA, C-O-W, and if it's not .com, it's .org. Okay. I don't remember. So you can go there, and they have some really, really great material. I think it's also the Department of Health for North Carolina, who also has some really great material.
Okay.
There are a good number of free options available. HIPAA Cow would be my first stop after the Department of Health and Human Services, though.
Okay, great. Well, we'll find out that URL for those of you who are listening in, and we'll post that as a resource link on our page, so we'll figure out if it's the .com or the .org. I don't think too many of us are going to forget the HIPAA Cow portion of it. Great. Here's another question. I am a legal nurse consultant, self-employed, and review medical records for claims and lawsuits. Do I need a business associate agreement with each client, and do I need to update that on an annual basis?
You do. You do. You need to have business associate agreements because that is protected health information. So,
okay.
Yeah.
Okay. I have another question here. What are your initial impressions or concerns with cloud computing types of business solutions to include online data storage providers, since these are relatively new and somewhat not well versed with HIPAA and business associate requirements?
So I've been around IT for a long time now, and cloud computing really isn't that new. It's a different name. It's a new name for a service that's been around for a long time. For example, shared hosting, right? It's a similar type of structure.
Okay.
Where you're putting your data into a third party's environment. My initial thoughts, I think my initial concern, as would be with a lot of attorneys, is compliance, right? Because you want your information to be protected and stored, and you want to make sure that the service you're using complies with the requirements of HIPAA, right? And so that means, for example, a large problem in shared hosting, for example, is that you're sharing space with a lot of different people, right? And you don't know what walls the provider has built between you and these other parties. How do you know? What's your guarantee that they can't get into your data from some back door, right, that people just don't know about or wasn't adequately secured or things like that? That's a similar issue that you have in cloud computing. How do you know that those doors are secure? I think you'll find more vendors now who are complying with the process, who are carefully assessing their services. I know Online Tech has done a very good job of making sure that they are in fact compliant. They've done the risk assessment. They've gone through that process. And you'll find other vendors who want to get into this space who are doing the same thing because they understand that covered entities and other parties are just not going to trust them without doing that process. I think if you're looking to a vendor, you want to use a cloud computing vendor, the first thing you should ask them is, have you done a risk assessment, right? If they say, I don't know what that is, you should go ahead and walk out the door and go to someone else. If they say, yes, we have, you probably want some sort of certification. Show me the proof that you have done that. Tell me who you used, whatever the process is.
So what would someone ask for specifically to see? I mean, I assume that there's some type of formal report that is the result of the audit, or maybe that varies across the board.
It varies across the board. It really does. There's no one size fits all. What you want to make sure is whoever the company used for the risk assessment is a reputable provider, and they certify. And then you get that in writing from the vendor. Yes, we attest and we warrant that this is true, that we are liable if this isn't true and all of that. I mean, again, your protection is your contract, right? But keep in mind that your contract is only as good as either the insurance policy or the provider's pocket, right? Because if the person is judgment-proof, then your contract really does you no good. So again, you want to go to someone who has the means to live up to what they're promising. And that's really it, because you will see, and I know I've seen this because I've done the research. There's a lot of people who say a lot of stuff online, right? Sure. They say, we can provide this, we can provide that, we can provide this, we can provide that. But when you do more research, you find out, hey, they're a reseller for some third party. In fact, they can't provide that because they don't provide that now, right? They're reselling services for someone else, and so they can't actually live up to those promises because they're relying on some third party who may be relying on some other third party and so forth up the chain. So you just want to make sure you do your due diligence. Okay. Because as with the Stanford case, who pays the price?
Everybody.
Right.
So would it be unreasonable or is it unheard of for potential clients to ask for a copy of the final auditor report?
No, it's not unreasonable. You will want to have them sign some sort of confidentiality document because you probably don't want that disclosed. Depending on what was in the audit, there may be certain protected secret information that you definitely don't want disclosed, like your entire security process. You don't want that disclosed to just anybody because right. Now that's a liability.
Right.
Right. So I mean, you may get one that's a little audited or redacted, right? And so you want to be careful what you're revealing because, again, there's certain things you don't want to reveal because that is how you protect everybody. The less people know, the better, right? Because then they don't know your vulnerabilities.
That makes a lot of sense.
Yeah. Got
to be careful all the way down the line here, don't you?
You do.
And Frank, thanks for that feedback he's sharing here that it is indeed HIPAACOW.org.
Thank you.
HIPAACOW.org. So thanks, Frank. Appreciate that. If there are any other questions, we'll take a last question or two, and then we'll go on and wrap up here.
I just want to get to one more slide that I have. I have this as a regular question. And is it okay to send documents via email or fax? So email is not a secure form of communication. So no, it's not.
Okay, period.
There are many services that provide secure services to send email. And if you're going to do that, you should be sure that you're using one of those services. Fax is okay, so long as you have the proper warnings and disclaimers on the cover page that this is PHI and so forth. But be wary of fax to email because, again, you're getting into email.
Okay.
And email is not a secure form of communication.
Okay, good to know. All right, well, thanks so much, everyone. You've sent some great questions. Tatiana, thanks again for your time and expertise. Always appreciated.
Thank you so much for having me.
Wanted to let everyone know that Online Tech and Tatiana as well will both be down in Indianapolis next week. So if you have further questions about the implications of high-tech, HIPAA, or business associate agreements, or if you have any questions about HIPAA-compliant data center services, come on over and see us. We'll be at booth 57. And we're having an open house Friday, December 2nd at our latest data center that's just opened in Ann Arbor, Michigan. We welcome you, if you're in the area, to come join us. And finally, we'll be out at the annual HIMSS conference in Las Vegas, February 20th through 24th. So we hope we get a chance to meet some of you there. And in the meantime, have a great day. Thanks again, Tatiana.